Thank you very much, Mr. Chairman. Hello, Judge.
Hi, Senator.
Hello. I want to start out again by reminding friends at home, people at home, that this isn't normal. We shouldn't be here right now. We are in the middle of the pandemic and people are sick. We are in the middle of the election and people are voting. And yet here we are stuck in a nomination hearing. I know what my constituents care about, what they've been calling and writing me about. And that is they are afraid of losing their health care in the middle of the pandemic. People's lives depend on the Affordable Care Act, like Steve, a senior from Tower, Minnesota, who has a heart condition and relies on his prescription medication. Emily from Minneapolis, mom was diagnosed with breast cancer. Janet from Rochester, whose brother has a mental illness. Or Christy, a mom from Bloomington, whose daughter had a tumor. That is what is on the line. Health care is on the line. And Judge, that's what's on the line in your nomination hearing, which unfortunately has been plopped in the middle of this election. This morning you had, I would call it an academic discussion with Chairman Graham about the doctrine of severability, and that's about if you can uphold part of a statute but throw out another part of it. And you correctly said there is a presumption to save the statute if possible. So I want to be really clear with the American people that the Trump administration's own brief, this is the position of the Trump administration, filed by the Trump Justice Department, says that the entire Affordable Care Act must fall. That is the position of the Trump administration going into this case that's going before the Supreme Court in a few weeks. Judge, you clerked at the Supreme Court. Does the Justice Department's brief that they have filed represent the administration's and therefore the president's position before the Supreme Court?
The Solicitor General is the government's advocate before the court.
Right.
Yes, that would represent the United States.
Right. And if the brief didn't represent the president's position, he would have the Solicitor General and the Justice Department withdraw the brief. Is that right?
I believe so, yes.
Okay. I just wanted to make that clear to the chairman and to everyone out there that while there is this doctrine to separate stuff and to try to uphold part of the statute, like maybe pre-existing conditions or doing something about keeping your kids on the insurance, the position of the Trump administration is to throw the whole thing out. The second thing I want to make clear is that you have been nominated to the highest court in the land, and you will be the deciding vote in many cases that will affect people's lives. And I appreciated that you've said it's not the law of Amy, it's not your law, but the point is that you will be in a really important position. I think that's one of the reasons that they're trying to ram through this process right now. And while you're not saying how you're going to rule on cases, as I said yesterday, I've been following the tracks, and the only way for the American people to figure out how you might rule is to follow your record and to follow the tracks. And we know this. You've said you consider Justice Scalia one of the most conservative judges in our nation's history as a mentor. You've criticized the decision written by Justice Roberts upholding the Affordable Care Act. In a 2015 NPR interview, you praised the dissent by Justice Scalia in another Affordable Care Act case, saying the dissent had the better of the legal argument. You signed your name to a public statement featured in an ad that called for an end to what the ad called the barbaric legacy of Roe v. Wade, which ran on the anniversary of the 1973 Supreme Court decision. You wrote your own dissent disagreeing with longstanding court rulings on gun safety, expressing your legal opinion that some felons should get guns, and you once discussed a dissent in the marriage equality case asking whether it was really the Supreme Court's job to make that decision. So to me, these tracks lead us to one place, and that is that you will have the polar opposite judicial philosophy of Justice Ginsburg. And to me, that would change the balance of this court, which is already 5-4 and known as very conservative when you look back through history, to 6-3. 6-3. And that would have great repercussions for the American people. So I wanted to follow up on something that Senator Harris and I asked you about yesterday, and that is the issue of whether or not you understood the president's clear position on the Affordable Care Act before you wrote the article in which you criticized the legal reasoning for upholding the Affordable Care Act. The president tweeted just one day after you were nominated, that would be September 27th, that it would be a big win if the Supreme Court strikes down the health law. But before you were nominated, and this is what we showed yesterday, Donald Trump tweeted promising that his judicial appointments will do the right thing on Obamacare, unlike Justice Roberts. Yesterday, you were asked by Senator Harris, prior to your nomination, were you aware of President Trump's statements committing to nominate judges who will strike down the Affordable Care Act? You said, I can't really definitively give you a yes or no answer. What I would like to say is I don't recall hearing about or seeing such statements. And after she followed up, you said that the tweet wasn't something that I heard or saw directly by reading it myself. Okay, so I just want to go through some of the things that have happened over the last few years regarding the president's, his obsession to repeal Obamacare. He said, we will repeal and replace disastrous Obamacare when accepting the Republican nomination at the Republican convention in 2016. Did you see that speech?
At the Republican convention
in 2016. I'm not asking if you were there. I was asking if you saw it on TV.
No, I don't believe I watched any of the convention on TV. Or
Okay.
I did. I don't remember any of it.
He has said things like, it begins, he wants to immediately repeal and replace the disaster known as Obamacare. He has said that he wants to get rid of it. He has said in States of the Union, I am calling on Congress to repeal it. He said, can you believe that Mitch McConnell, who has screamed repeal and replace for 7 years, couldn't get it done? So there have literally been hundreds of statements by him, by my colleagues, and I just find it hard to understand that you were not aware of the president's statements.
I am aware that the president opposes the Affordable Care Act. I'm aware that he has criticized the Affordable Care Act. I took Senator Harris's question yesterday to be referring to the specific tweet, maybe the one that you have behind you, about how he wanted to put a justice on the court to replace Obamacare. Mm-hmm. And I'm definitely aware of that tweet now. And as I said to Senator Harris yesterday, it came up in some of my calls with Democratic senators, brought it up. But I honestly can't remember whether I knew about it before I was nominated or not. I'm not sure.
But did you have then a general understanding that one of the president's campaign promises was to repeal the Affordable Care Act when you were nominated?
As I said before, I'm aware that the president opposes the Affordable Care Act.
Well, I know you're aware now, but were you aware back then?
Well,
when you were nominated?
Well, Senator Klobuchar, I think that the Republicans have kind of made that clear. It's just been part of the public discourse.
Okay, but then is the answer yes, then, that you were aware
Senator
of it?
Klobuchar, all these questions, you're suggesting that I have animus or that I cut a deal with the president, and I was very clear yesterday that that isn't what happened.
Were you generally aware of the president's statements when you wrote in an article in the University of Minnesota Law School Journal in 2017, the same year that you became a Seventh Circuit judge, that he pushed the Affordable Care Act beyond its plausible meaning to save the statute, that Justice Roberts had done that? Were you aware of that, of the president's statements when you wrote that article?
So that article, Senator Harris told me yesterday, was published in January of 2017. Okay. And a law review article takes several months to go into production. So I can't remember specifically when the conference was. That article came out of a conference for Randy Barnett's book. I can't remember when it was, but I suspect it was before the election. It's not like I wrote it in January of 2017.
But President Trump has been saying this in 2015, in 2016, and that's 2 years. It didn't take you that long to write the article. So my question is simply, were you aware of President Trump's opposition to the Affordable Care Act during that time?
Senator Klobuchar, I have no idea, and I suspect that if the article was published in January, that I wrote it sometime before the presidential election. And again, I want to stress, I have no animus to or agenda for the Affordable Care Act. So to the extent you're suggesting this was like an open letter to President Trump, it was not.
Okay. In the 2017 University of Minnesota Law School Journal that we just discussed, one of the things you said is there is a risk that a faction can run away with the legislative process, but there is also a risk that a faction will conscript courts into helping them win battles they have already lost fair and square. That's something you wrote in that article?
I did. I was responding to an argument made by Randy Barnett in his book, No, I don't know if it was Our Lost Constitution or not, but yes.
So, I mean, that is what I'm afraid has happened here. They have tried 70 times, the Republicans in Congress, to overturn Obamacare. And now they are bringing this case to the court, and you are going to be sitting on the court. And I find it very hard to believe that you didn't understand that when you wrote the article. So I want to, there's one other piece of this, and that is the effect on the economy. And we all know this has been very difficult. My colleagues know this. According to one Yelp study, more than 800 businesses have closed every day. 30 million people were out of work at the height of the pandemic. We're still down 10 million jobs. And so one of the things that's been going on here is we've seen more and more consolidation, and leading me to antitrust. And that part of this, I think, is the COVID relief package we have to pass, but also antitrust. Competition is a driving force of our economy. Justice Ginsburg, at her nomination hearing, described the Sherman Act as a broad charter. She said that free enterprise is the spirit of the antitrust laws, and the courts construe statutes in accord with the essential meaning that Congress had for passing them. Do you agree with her statement?
The Sherman Act is broadly worded, insofar as it prevents contracts, combinations, and conspiracies in restraint of trade. And because that language is broad, courts have developed a robust doctrine of common law to enforce and bring about its promise of eliminating contracts, conspiracies, and combinations that restrain trade.
Yes, and I think you and I have discussed this before, but in recent years, Supreme Court opinions, by the way, all decided over Justice Ginsburg's dissent, have made enforcing our antitrust laws even more difficult. As a textualist, how would you reconcile the broad language of the Sherman Act with recent judicial precedent that has substantially narrowed the application of the statute in practice?
Let's see, I can say as a textualist how I would approach the Sherman Act. And in the case of the Sherman Act, you're right that it's broad language. The text of the Sherman Act, as the court has determined over time, essentially permits the court to develop a common law. So I think, I haven't really had occasion to decide very many antitrust cases on the Seventh Circuit, but it's an area, because it's largely been left to judicial development, that is controlled by precedent for the most part.
Mm-hmm. It is, and that's my concern right now, is that it has been so narrowed in its interpretation of the Sherman Act, the Clayton Act, that it's almost become impossible for people to bring those cases in any big way. I want to turn to something we talked about yesterday, which is elections. You worked on the recount in Florida that was related to the Bush v. Gore case, including on an absentee ballot issue on behalf of the Republican side of that case. Is that right?
I did work on Bush v. Gore. I did work on behalf of the Republican side. To be totally honest, I can't remember exactly what piece of the case it was. There were no
Don't worry,
challenges.
I'm not going to ask you that.
Okay.
We're in the middle of a global pandemic that is forcing voters to choose between their health and their vote. Are absentee ballots, or better known as mail-in ballots, an essential way to vote for millions of Americans right now?
That's a matter of policy on which I can't express a view.
Okay, to me, that just feels like a fundamental part of our democracy. But okay, let's try this. Have you ever voted by mail?
I can't recall a time that I voted by mail. It may be in college that I did when I was living away from home, but I I can't, as I'm sitting here, specifically recall a time I voted by mail.
Do you have friends or family that have voted by mail or are voting by mail?
I have had friends or family vote by mail.
And you understand we're operating in a moment where the president is undermining vote by mail, even though a number of Republican governors and Republican senators are supportive of it. Many argue that Bush v. Gore, and back to your earlier work, hurt the court's legitimacy. If you are confirmed, the Supreme Court will have not one, not two, but 3 justices, you, Justice Kavanaugh, and Chief Justice Roberts, who worked on behalf of the Republican Party in matters related to the Bush v. Gore case. Do you think that that's a coincidence?
Senator Klobuchar, if you're asking me whether I was nominated for this seat because I worked on Bush versus Gore for a very brief period of time as a young associate, that doesn't make sense to me. I
just think it's such a coincidence to me. I actually didn't know it until yesterday. But will having justices with this background, 2 of whom were appointed by the current president, decide any cases related to the upcoming election, do you think that will undermine the legitimacy of the court?
Asking whether something would undermine the legitimacy of the court or not seems to be trying to elicit a question about whether it would be appropriate for justices who participated in that litigation to sit on the case rather than recuse. And I went down that road yesterday saying it's a legal question.
You said you wouldn't recuse. That's why I thought it was
That isn't what I said. I said I wouldn't commit. I wouldn't pre-commit.
That you're right. You said you wouldn't announce your decision on recusal, and you wouldn't commit to recusing. But again, I think the public has a right to know that now 3 of these justices have worked on the Republican side on a major, major issue related to a presidential election. One thing I wanted to revisit quickly, Smiley v. Home. The reason I asked about that is that this would be unprecedented when right now we're in an unprecedented time where we have a president who refuses to commit to a peaceful transfer of power, working to undermine the integrity of this election. And yesterday you wouldn't commit to recuse yourself from the case we just talked about, but now we're considering your confirmation to the highest court in the land in the midst of this election. And in Smiley v. Home, where the Supreme Court held that a governor is part of the legislative process, and therefore a legislature cannot unilaterally change election rules, that could be very important because we have a number of swing states where we have legislature of one party, governor of the other. And we have this precedent that has been on the books for nearly 90 years. Do you think that that is established Supreme Court precedent? It said that a governor is part of the legislative process.
I actually am not familiar with that case, but it is precedent. Obviously, it's a precedent of the court.
Okay. I wanted to turn to one last issue, and that is First Amendment and freedom of the press, near and dear to my heart. My dad was a journalist. He would go everywhere for a good story and cared a lot about freedom of the press. And regrettably, our right to a free and independent press is under assault. We have witnessed unprecedented attacks on journalists and journalism in the past several years. Our president frequently uses his Twitter account to attack news organizations. He has accused the media of being fake news and called them the enemy of the people. Obviously, we also have journalists overseas that are under attack by dictators. I want to pay special tribute to those brave journalists whose dogged pursuit of the truth never wavered despite threats of imprisonment, violence, and even death. Journalists like Jamal Khashoggi and the men and women of the Capitol Gazette. Their legacy is proof that fear will not silence facts. The founders recognized that a free press is vital to a vibrant and strong democracy, and that's why we need Supreme Court justices who understand the importance of protecting the right of journalists. First Time v. Sullivan, you know that's a landmark ruling and with the support of the First Amendment protections for the press and protecting journalists unless they say something untrue with actual malice. Justice Thomas has expressed skepticism with that case, writing in his concurrence in McGee v. Cosby that if the Constitution does not require public figures to satisfy an actual malice standard in state law defamation suits, then neither should we. Do you agree with Justice Thomas that the court should reconsider the actual malice standard because it is inconsistent with the original meaning of the Constitution?
Well, Senator Klobuchar, I can't really express a view on either New York Times v. Sullivan or Justice Thomas's critique of it without violating the principle that I've repeatedly stated that all nominees follow, that, I can't comment on matters of litigation or grade precedents that the court has already decided.
I also want to ask you about how journalists have been deterred from doing their jobs under the threat of jail time. After the Supreme Court's 1972 decision in Brandsburg v. Hayes, many federal courts of appeals have recognized what's called the reporter's privilege, which protects a reporter's First Amendment right to protect his or her sources from disclosure in certain circumstances. The Seventh Circuit, by the way, on which you serve, has rejected a constitutional basis for a reporter's privilege. Under its original public meaning, does the First Amendment protect a reporter's decision to protect a confidential source?
Well, again, that would be eliciting a legal conclusion from me, which I can't answer in a hypothetical form in the hearing. It's also a question, as you point out, that's closely related to ones that are being litigated.
Okay, one last try. Do you agree that if reporters cannot protect their sources, they are less likely to be able to find confidential witnesses willing to share information, confidential informers willing to share information about issues of public importance?
Well, Senator, that would both be a policy question, a matter of public policy, which I can't express a view on, and presumably also one that might factor into the question of what the First Amendment protects. So again, that's not something that I can give an opinion on in this context.
Okay. I guess my last thing I'll just say is I hope people watching out there are going to follow the tracks of this record and are going to vote. Thank you.
Thank you. Senator Sass.
Thank you, Chairman. Welcome back, Judge Barrett. Let's start with how judges should look back on their